Hello and welcome to the IP Australia podcast, and this is our series for small business and startups. My name is Lisa Cohen. I'm the Director of Public Education at IP Australia. For those of you who aren't familiar with IP Australia, we're the government agency that administers intellectual property rights, also known as IP rights, in Australia, and I want to thank you for tuning in today. Before we dive into this episode, I'd like to begin by acknowledging the traditional custodians of the land which I'm coming to you from today, which is the Ngunnawal and Ngambri people in the beautiful ACT. Now, in today's episode, we're going to talk a little bit more about how to apply for a patent. I'm looking forward to this one, so let's get started. Hi everyone and welcome. In the previous episode, we did an introduction to patents and we discussed the reasons that you might want to look at getting a patent to protect your invention and some of the benefits that it can offer. One of the things we argued about was whether it would be patent or patent. So I think we agreed that it just is up to you. We're not going to make any judgments here. Now today in this episode, I'm joined once again by my fabulous subject matter experts, senior patent examiners from IP Australia, Sam Saals and Lachlan. Welcome back for part 2.
Thanks so much for having us back, Lisa.
Thanks, Lisa. Excited to be back. We've got lots more to talk about.
Lots more to talk about. Unfortunately, we've only got today's session and that's it, because I know that we could probably go for days. But in today's session in particular, we're going to talk a little bit more about how to apply for a patent, the steps involved, what happens after you secure a patent or after you're granted a patent, and the things that a patent owner might want to consider when they're looking to commercialise their invention or idea. So what are the key steps that are involved in a standard patent application process?
Yeah, so the first step when you make that application is applying online via the IP Australia website. And in that application, that'll include a detailed description of your invention, along with claims, an abstract, and any relevant drawings. You can then request examination of that application either at the exact same time you file or within 5 years of submitting your application. IP Australia, and in particular an examiner like me, will then review your application to determine whether your invention meets all of those requirements that we discussed in the last episode. The things like whether it's new, whether it's inventive, whether it's useful. If we find any issues at all in that review, we'll write you a report outlining those concerns. And that's a really, really normal part of the process, very common to get a report from us. You'll then have the opportunity to respond to that report, make any changes that you need to make to your application, and if after that all of the requirements are satisfied, then your patent will be granted. It is really important to be aware though, that whole process can take up to several years to complete. Once you get to the end of it though, if you get a granted patent, that is what gives the patent owner legal protection. A patent application on its own that's not granted doesn't give you any protection. You can think of a patent application kind of as a patent pending.
Yeah, and sometimes we do see that on products, don't we, where the business might write patent pending.
It's like a big sticker in the top right hand of the box.
That's right. It's like, don't try and copy this. We've got a patent application.
It's on its
I feel
way.
like it's one of the things that comes with being a patent examiner is your eyes see those patent pendings everywhere they come up.
It's great thanks for explaining that, because I think it's really good for the listeners to understand what that means if they see it elsewhere. Now, I just want to ask a couple of quick questions, Sam, if you don't mind about that. What's an abstract?
The abstract is really just a summary. It's a sort of 1 paragraph long description of the invention and all the most important features. Just a quick summary.
Pitch.
Yeah, that's it, the elevator pitch.
Perfect. Thank you. And if you do, file the application and a report is written, is the examiner's phone number on there so that the applicant can give you a call and have a chat?
Yeah, absolutely. Once an examiner gets assigned, they'll have their phone number on there and also the phone number of their supervisor as well. So you should always be able to contact them if you want to check on any of the issues that were raised. Feel free to give us a call. We're always happy to have a chat about them.
Oh, that's fantastic. And I just think for the listeners, it's so good to be able to talk to a human, particularly the human that wrote the report. Our IP report 2025, little plug, the IP report has a study in there about the flexibility of that system. You mentioned that it could take a couple of years or up to 5 years to have a patent granted, but there's some benefits to that if you're a small business. So please do hop into the IP report and have a look at the patent pendency data or research. It's actually really interesting. It shows that the the system can work to the benefit of small businesses. So that's fantastic. Now, I'm really interested, and I'm sure our listeners are too, that you've talked about the application process, but what are some of the common mistakes that people could try to avoid during that process?
Well, Lisa, we do see a few mistakes during the application process in constructing the application and then also in response to some of the reports that we might write. And some of these mistakes include things like poorly written applications with vague descriptions or unclear claims. And just to stop there for a second, it's really important to have a comprehensive and clear application, because that is the thing that examiners are able to read and understand how your invention works. So by not being clear enough there, it can impede their ability to understand exactly what it is you want protected. Some other mistakes can include things like missing deadlines, not seeking professional help where it would be useful, and filing in the wrong jurisdictions. We've spoken a bit about patents being territorial. So this means that if you only file in your home country, but your market is global, it can leave your invention unprotected in some key markets.
Thanks, Lachlan. I'm just going to scratch at that comprehensive and clear piece. I just want to make the point that we've noted earlier with Sam that the examiner's name goes on the application, and that's something really important, I think, when people are filing. You're not applying to a machine. You're not applying to an automaton. It isn't a box-ticking exercise. There is a human who reads your application. So make sure that it is clear enough and defined enough for a human to be able to read it and apply the legislation to make sure that it is easier to be granted or understand. The report could get sent back to the applicant. Are there circumstances in which a patent application might actually be rejected?
Yeah, so generally, when we think about a patent application being rejected, it is in the form of that report that we send, where you do get a chance to respond to any of those objections there. So that could mean you might respond by amending your application to overcome those issues identified, or it could mean that you provide some arguments as to why the examiner's objection don't apply. Maybe we've just misunderstood something. If the issues, though, can't be resolved within 12 months of that first report, then at that point, the application would lapse and would not be able to proceed to a patent. It is important with that to note, though, that a standard application that has lapsed does still become part of the prior art base. It's still published on our website. So it's important to know that that application would still then be able to be used to assess the novelty and the inventiveness of later inventions. And that could be both competitors or your own future patent applications as well.
Yeah, I think this is such an important point, Sam, because we spoke earlier about provisional applications, and what you've talked through there is just another benefit of using the provisional filing or the provisional application to help avoid this. Once you submit a standard application for a patent, irrespective of whether it's granted or rejected, it will be published on the patent database, and so your idea will be disclosed. So make sure, it really pays, doesn't it, to have a really well-crafted application. You want it to go through smoothly, you want it to be assessed. And of course, as we've talked about before, you can do that yourself, or you can employ an IP professional, such as an IP attorney, to help you with that. Okay, so you filed for your patent, you're waiting to hear. What can someone expect, and what might they do during that period while they're waiting for their registration to be granted?
Well, Lisa, what you might expect while waiting is expect to see communication from IP Australia. We will send you things like examination reports, meaning we've given you an opinion on your application, or we'll send you official notices. Regardless of which one, it's really important to respond to this communication in a timely manner. As to what you might do, there are actually a few steps that you can take just in that limbo period of waiting for the patent to get granted. You might begin approaching some potential investors or exploring other funding options if you do require that financial support to bring your invention to market. You could also use the waiting period to refine your invention, develop your business plan, and prepare for market entry. I guess the thing is with refining your invention, though, you want to make sure you're not straying too far from the invention that you actually are trying to get a patent for that's sitting with us. And finally, you might want to conduct some market research so that you can better understand your customers, competitors, and current market trends. So that research can help refine your business strategy and prepare for commercialization.
Yeah, there's another couple of things that I'd add to that, Lachlan, as well. You definitely want to be keeping an eye on the market for any potential infringements of your invention. If you do notice any, you'll definitely want to consult with a patent attorney and they can help you navigate that. Another thing to be mindful of is that there can be fees that come up during that registration process that need to be paid during that period. So you want to plan for those as they're necessary to keep your patent in force over time. Another thing to think about is that if you're considering international protection, there are some really tight timeframes there, so think about that early on.
That's great, Sam. That actually leads me into another question. If our listeners are planning on going global with their invention, what are some of the things that they should consider before they go for global domination?
Great question. As Lachlan mentioned, IP rights are territorial, so protection in Australia won't cover you overseas. You'll need to apply in each country where you want protection. So we covered this a bit in episode 3, but a really good option there is the Patent Cooperation Treaty, often abbreviated as the PCT. That lets you file one international application that covers multiple countries. It enables you to work in just one language and one currency. Another thing that you need to think about, though, going through that process is potentially having representation in all of your target markets, like local partners or offices. That can significantly improve your chances of success. I think I saw some research from the Export Council of Australia that backed that up.
Yeah, I read that too, Sam. It talked a bit about the greater chance of success in a foreign market if you had local representation. And here in Australia, if you're living overseas and you want to apply in Australia, you actually have to have local representation, don't you? You have to have a local address for service. So it's probably similar in other countries as well. While we're on the international piece, we often get asked, is there a global patent? You know, people go, oh, I've got a worldwide patent. Is that true?
As we discussed last episode, there's no such thing as a global patent. If you don't apply in those other jurisdictions, you won't be able to stop any copycats in those other countries. So think about it really early on, back yourself and your growth plans. We've got a lot more information about all of this on our website, or of course you can talk to an IP professional.
Thanks, Sam. Look, that leads me to another question. I think when our listeners are deciding whether they're going to go and apply internationally, that's all part of your business strategy, isn't it? And it's fair to say that you do need to have a strong IP strategy that runs alongside or as part of your business strategy. Do you have any insights on how to shape a strong IP strategy for our listeners?
It's a really good idea to keep updating your IP strategy depending on what you're doing. A great example of that is a company called Scootboot. We've got a case study on them on our website. For them, as their product line expanded, they entered lots of different global markets, and so they adapted their IP approach to secure over 20 patents across different jurisdictions. And having that proactive strategy really helped them to protect their innovations effectively and navigate legal challenges.
Sam, it sounds like the number one thing is that IP strategy should just be flexible.
Yep, that's exactly it.
Perfect. And also, you might need a portfolio of IP rights to protect your business all round. Trademarks, patents, possibly a design right. And if you're growing plants as well, maybe a plant breeder's right. That's great.
Yeah,
thanks,
absolutely.
Sam. So we've gone global and we've been granted our patent, and so we're ready to enter the market. I'm really interested, once I have my patent and my invention is fully protected, am I good to go?
Oh, Lisa, hold on. Let's talk about the words fully protected there. Because that's not actually entirely the case. What a patent does is it gives you important rights of protection of your invention, but it's not fair to say that it fully protects the invention. It comes with a lot of ongoing responsibilities once your invention is on the market. So you first need to maintain that patent by paying renewal fees to keep it valid. If you miss those payments, your patent will lapse, and then you will lose that legal protection. Secondly, enforcement is up to you. Patent protection is not an automatic thing. A patent gives you the right to stop others from using your invention, but doesn't automatically enforce those rights. You're actually the one who's responsible for monitoring the market, identifying infringements, and taking action. That could involve things like sending cease and desist letters, negotiating settlements, or even initiating legal proceedings. Finally, all that protection only is valid as long as your registration details are up to date. So if there are changes to the patent owner's name, address, agent, or even if the patent shifts in ownership, that has to be updated with IP Australia to ensure that those patent rights remain enforceable.
Thanks, Lachlan. That's a really good explanation. And I'll just pick up on two things there. One, please keep your registration details up to date. It's up to you. You'll get an online account with IP Australia. And if there are any changes to ownership or your address for service or anything like that, please do make sure that they're kept updated. Remember, a patent lasts 20 years or up to 25 years. That's a long time and things might change. So just make sure you do that. And the second thing is that IP Australia doesn't enforce registered IP rights. The enforcement function belongs to the owner of the IP right. So let's talk about that for a minute. Imagine that you own a patent and you can see that someone is infringing on that. So they're copying you or they're producing something that's using your idea. What are the options?
First of all, I'd say definitely consider engaging an attorney. They're the people who are just really the experts in this area. So definitely chat to an attorney. One of the options that they can consider is sending a letter of demand to the person that you think might be infringing your patent. So we might call that the alleged infringer. And that letter can outline your rights and the alleged infringement. And often that on its own can resolve the issue. On the other hand, if that doesn't resolve the issue, some other options we've heard are mediation and arbitration can be helpful to find common ground. Now, I'm not an expert in those areas at all. My understanding is that that can be kind of a discussion between the two parties, possibly sort of, I guess, helped by a third party to kind of try and find what that common ground is. And that can be a lot quicker and easier than going to court. If that doesn't work, though, the option is that you could initiate legal proceedings in the federal court. If that's successful, you could receive damages for the infringement. So essentially, you could receive a payment, I guess, based on someone infringing on your patent. But our listeners should note that legal action can be really costly, so they should consider carefully all the options available. As I mentioned, patent attorneys can really be helpful dealing with potential infringements. They can provide lots of advice. They can provide advice as well on licensing and assignment of patent rights, and also on creating an IP strategy for your business. IPTA is the Institute of Patent and Trademark Attorneys. It's a peak body, and you can read about some of the free consultations that they offer on their website.
Thanks, Sam. Now let's start looking forward. We've got the patent. We're ready to go to market. Let's talk about commercialisation. What does commercialisation mean in the context of a patented invention?
Yeah, Lisa. So we've spoken a lot about commercialisation, I guess, already, but we haven't really defined it. In this context, commercialisation means turning your invention into a product or service that generates revenue, taking the invention that you've just gotten a patent for and making a business out of it. Doing that can involve market research, product development, manufacturing, marketing, and sales. Essentially, making your idea work in the real world. If you want to do this, it's smart to include an IP strategy in your commercialization plan from the get-go, as that will help you avoid issues further down the track. As a patent owner, you may launch your product independently, or you could choose to collaborate with others and bring that product to market. So you can choose to license, partner, or sell the patent in order to overcome any barriers or limits that prevent you from reaching wider markets. Identifying those barriers and then how you might get around them is one of the reasons why you'd want to have that IP strategy in the first place. There's another common misconception that we hear, which is that only really large companies can actually successfully commercialize IP. And so while it's true that large companies often do have more resources, small businesses, startups, and even individual inventors can absolutely commercialize their IP successfully. Innovation isn't limited to big corporations, and some of the most impactful inventions have come from small teams with big ideas.
Thanks, Lachlan. That's so good. And we see that all the time. You know, the seed idea or the big idea comes from a small team and then it gets built on over time. And actually in the IP report 2025, we also have some information from that or research that shows that small businesses are actually coming up with more ideas and more innovations than large businesses in the last 24 months, which is really interesting. We've heard from people that we engage with at events and through our partnership networks that there's an assumption that once you own the patent, it is your responsibility to generate revenue by manufacturing the product yourself. And of course, not everybody wants to do that. So what are some of the options that a patent owner has to generate revenue from their invention?
Yeah, I mean, I think that's really one of the great things about patents is that you don't have to actually manufacture the idea yourself. There's lots of options like assigning, licensing, or franchising the patent. That first one, assigning, I think Lachlan mentioned you can sell it. You can sell the patent outright. That transfers all the rights and frees you from any future responsibilities. Second one I mentioned there was licensing it. That's if you want to keep ownership but let others use it. You can earn royalties and can reach markets that you wouldn't be able to on your own. And then you can also franchise it. That's a lot more common with large enterprises, but it means you can grant the rights to use the patent and other IP to multiple franchisees to earn fees while scaling your invention. And I think the important thing here is there's really no one-size-fits-all approach. It just depends on your goals, resources, and the nature of your invention.
That's amazing. So I had no idea there was so much flexibility. So once you own the patent, it's really up to the patent owner or up to you how you generate the revenue, whether you do it on your own, with others, whether you sell it. And of course, don't forget to update the IP register. You sell it. There's quite a bit of flexibility with individual circumstances. That's a great overview. Thank you. Now, let's talk about collaboration. So you've got the patent. You want to bring it to market. You might need to collaborate with another organisation. You want to come together to make it better. What should a patent owner know?
Yeah, Lisa, it's like I alluded to earlier. Collaboration is all about, I guess, overcoming barriers by working with others to get your invention out to the masses. And so something that patent owners should know before doing that is that it's always really good to clarify ownership early on. That will avoid disputes and ensure that everyone's rights are protected. The reason we talk about that is because IP can have more than one owner. It can belong to businesses, organizations, or individuals. And so in the instances of belonging to businesses or organizations, there are typically collaboration agreements in place. So if two or more parties have created an idea together, they are typically joint owners. That means that if you've got joint ownership, if you're considering that each party can also bring existing IP into the venture, new IP can be co-created, you can end up with a real mess of ownership. It's really important to clearly define ownership in your contracts. We've heard of a lot of good work being shelved or moving at a glacial pace just because parties can't agree on ownership after development. Don't let that happen to you.
I don't know, Sam, what do you reckon? That sounds like a prenup for a marriage. Is that right, Lachlan? Or you've got to sort out who owns what before you go into it so that if it all falls apart in the end, you all know who owns which bit.
Look,
Don't
Lisa,
have a messy divorce.
Sometimes it's better to be safe than sorry.
Yes.
Now, look, we've spoken about it a few times as well, but if you're collaborating as well as having that ownership clarified, you might want to consider the use of non-disclosure agreements too with the parties involved, just so that there are no accidental slip-ups. You can always as well seek professional advice to help shape your strategy for commercializing your patent.
Well, look, I'm ready to come to the end of the show and to wrap up today. Is there anything else that either of you would like to add for our listeners in this episode?
I think that really if there's one thing that you might come away with this is how important the idea of planning and forethought is to IP strategy. It's about knowing where you want to go and what you need to have in order to get there.
I think the other big theme that came to me was really around flexibility, and that all of this commercialization and IP strategy, it's all about something that works for you and your business.
And what great insights to finish off today's episode. Lachlan, Sam, thanks again for joining me today.
Thanks so much for having us, Lisa.
It's been a pleasure.
And we really hope that you, the listener, have learnt something more about patents. Please don't hesitate to reach out to IP Australia. We've got the phone number for our fantastic customer service team in the show notes. And of course, our website is there. And so we'll say farewell for this episode. Gosh, that was another great conversation on patents. I always learn so much. Just a quick note before we finish. The content shared in this podcast isn't intended to be taken as legal, business or professional advice.